I think you had the list of folks who were
So I'm at 100% right here.
joining. Do we have other folks who were waiting? I think Judge Maderi we're waiting on, and Judge Evans.
Judge Evans is calling in.
Judge Raddick.
Oh, that's right.
Yeah. Okay.
Use your Surface Pro.
And Megan, you've already started the YouTube stream just now? Okay.
I've got this wireless speaker right here, but I don't know if that's gonna, if there's anything we can.
Judge, would you like to wait? Oh, here's Chief Justice Raddick. Would you like to wait a few more minutes, or should we jump in?
Whatever you think. Sometimes it takes people a while to get in.
Yeah.
Hi, guys.
Maybe another minute.
Hi, guys. Hi, Jeff.
Judge.
Hey, Judge.
Hello.
Oh, we have slow people like myself.
Couple more. You're not last.
Okay, good. You're not really in the courtroom though, are you?
I am not. I am in my desk in my messy office at home.
Well, you look very professional.
Thank you.
You had me fooled.
I can show you the background, but I won't.
That's okay. I'm not that curious.
Yeah.
Any update on appointees?
No. Have you heard anything else?
No.
No.
I did hear, and Jeff, I was hearing that Glenn Hager said it's not as dire as he first thought.
Right.
Wouldn't that be good?
Yeah, that'd be fantastic.
This is Judge Evans. I finally got in.
Hi, Judge.
Hi, Judge.
There we go. Our computer system crashed, so I'm on the phone.
Okay. Jeff, what do you think? Should we get going?
I think so. I think we're good.
Okay. And I'll call the meeting to order and ask for the roll call.
Okay, roll call. The Honorable Sharon Keller.
Here.
Mr. Alex Bunnan.
Here.
The Honorable Valerie Covey.
Here.
The Honorable Brandon Creighton. The Honorable Richard Evans.
Here.
Mr. Gonzalo Rios.
Here.
The Honorable Nathan Heck. The Honorable Missy Maderi.
I'm here, guys. I'm also on a Board of Judges meeting that I'm kind of on two screens on. So when it comes to my part, I'm going to turn it over and I'm going to try to jump back and forth. But we're trying to get our jury plan going, and it's kind of, I got to be on this other meeting, okay? Sorry, Judge Keller. Thank you.
That's fine.
The Honorable Nicole Collier. The Honorable Reggie Smith. Sorry.
That works. Yes, I'm here. Thank you.
The Honorable Sherry Raddick.
Here?
The Honorable Vivian Torres.
Here.
The Honorable Judge Whitmire. Judge, we have quorum.
Thank you. Is there a motion to approve the minutes from the last meeting?
There's a couple of corrections that
okay.
With respect to the Kerr County FY 21 improvement grant, I believe Judge Evans and I abstained from that vote. It shows that the motion passed unanimously under grants and reporting. That's on page 3. Well, on page 1 of the minutes, page 3 of the packet.
That would be correct. We both abstained.
That's it.
Okay. Anything else? Okay, I guess we can just make that change, right, Jeff?
Yeah, yes, we can.
Okay, is there a motion to approve the minutes as amended?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Okay, motion carries. Y'all, I'm jumping back and forth between screens here, but I think next is chairman's report. Is that right, Jeff?
I think that's right.
Okay, the only thing I wanted to mention, and I hope y'all look at this, is the new website. Jeff is not necessarily like trained to do websites, but he taught himself and he did a great job. He just looked at me and thought, you know what, this could be better. It could be more easily accessible. It could look better. And if you haven't looked at it, you're gonna really like it because it's very creative and imaginative, and it's just fantastic. And I think that I told them, I think when other agencies see it, they're going to go, we're just so jealous and we want Jeff to come do ours. But it is so much better. So I hope you'll take a look at it. It's really nice. And that was all I had to report on. So Jeff, I believe it is your turn.
Thank you, Jen. And thanks for, we have a second Reggie Smith joining us. Thank you. Yeah, hopefully you all like the new website. If you find anything that's amiss on the new website, please let me know. It's the same web address, but we want to make sure to correct anything that's wrong. But hopefully it's a little bit more visually appealing and a little bit easier to use than the old one. So thanks for mentioning that. A few quick things for the director's report. Our legislative appropriations request, we filed that a couple months ago. That grew out of our strategic planning. Really, we just had 3 requests, one exceptional item, which is the restoration of estimated appropriation authority. For those of you who aren't in the legislature a lot, estimated appropriation authority really just lets us spend whatever dollars flow into the account. We don't think that's a very big ask this session because our revenues are so far down. But we have historically had estimated appropriation authority. The other 2 are 2 rider revisions.
You know
And
what?
we're going to echo.
Yeah.
Do we still have 2 Reggie Smiths? That's probably what's doing it, right?
I think that might be.
Yes, ma'am. We're
Yeah.
changing computers, so I apologize.
That's fine.
Yes, ma'am.
So the other 2 rider revisions, one is really just kind of cleaning up, removing a rider that no longer serves any purpose. And the other is cleaning up, or actually adding some language to Rider 18, which enables TIDC to give funding to existing public defender offices. So we're hoping to existing public defender and managed assigned counsel systems as well. So that's the request. Happy to take any questions on that. We also filed, Chair Collier is not with us today, but there was an interim charge in the House regarding indigent defense. And we drafted a short written testimony that we submitted, gosh, a few weeks back now. I have sent it out to the board. If you haven't seen it or you want me to resend it, please let me know. I'm happy to share that. Judge Keller already talked about the new website. One thing that I wanted to lay the groundwork for pretty early on, there's nothing the board needs to do on this today, but we really have 2 websites. We have the main website, the one that we've just redone, and then we have the data website, which actually is quite a bit bigger than the main website. We have at this point a small mountain of data, and we use the data website for indigent defense expenditure reports. We use it for collecting indigent defense plans. We use it for receiving complaints. We use it for tracking and allowing applications for grants. So it's a pretty massive website. For years, that website has been run by the folks at Texas A&M's Public Policy Research Institute. And the people there, much like Judge Keller said, I am very accurately, I am not a programmer by any means. Thankfully, the folks at Texas A&M, even though they're in the same boat, they're not programmers, are quite a bit better than I am. And they've built this system, gosh, I mean, I think 10 years ago or so. And it served us pretty well. But one, it's aged, and I think you can tell the age from it when you look at it. But 2, and a little bit more pressing, the folks who program for them are about to retire. One person in particular, James Van Beek, who does a lot of the programming there. Now, the good news is we have a pretty long runway. He's not going to retire for another 1.5 years. So that gives us a lot of time to explore. So on the staff side, we've been talking to potential data vendors. We've been looking at private vendors. We've been looking at university vendors. We've talked to the Office of Court Administration. We really don't have any big findings just yet, but I wanted to kind of plant that seed early because basically a year and a half from now, it'll be a big conversation with the board. What do we do with this data website and the kind of small amount of data we have there? Last couple of things, the TIDC, the proposed legislation that this board approved back at the August meeting is attached to the director's report. So it is in your meeting materials if you want to take a look back at that. And then finally, a staff update. Kathleen Casey Gomez, one of our senior policy analysts, had a baby since we last met and is on maternity leave. She's coming back later on this month. Baby's name is Noah. Mom and baby are both doing really well. And I think I sent a photo of the baby out in one of my monthly director's reports. But if you want to see that, please let me know. I'm happy to share a photo with you. So, Judge, I think that's all I have, unless there are any questions.
Okay, thank you. Next is the improvement team report. Is that Scott?
Yes, thank you, Judge Keller. If you can turn to page 11 in the board book, you'll see the improvement team reports. Just wanted to update y'all real quick on what we've been up to. First off, as you know, we do planning studies for counties who are interested in establishing public defender offices and managed assigned counsel programs. We completed one of those planning studies for a public defender office in Ellis County this quarter. And we have 2 other requests, one for a regional public defender office and another to do a planning study for a managed assigned counsel program. So I'm currently working on those. In this past quarter, we have given technical assistance to a number of counties who we have, y'all gave grants to at the last board meeting to establish regional public defender offices and managed assigned counsel programs. Kathleen and I developed some onboarding resources for those counties. That includes checklists, all interlocal agreements, job descriptions, stuff like that. The Hill Country Regional Public Defender Office, we assisted them with many of these things that they need to do in establishing the office. They have put out their job description, job for the chief public defender. They are going to be interviewing candidates, I believe tomorrow. And so we sent that job description around the state and around the country, thanks to Jeff. The Galveston Misdemeanor Mental Health Public Defender Office, they too have put out a job description for the chief. That closed a few days ago, and they will be interviewing chiefs soon. And we've been helping the McLennan County Mental Health Managed Assigned Counsel program and getting that up and running. I've done a number of trainings and presentations over this quarter. In terms of the Future Indigent Defense Leaders program, our mentorship program, we have been hosting a lunchtime roundtable series on a monthly basis with TCDLA. We also have a monthly mentor-led discussion for mentees that we've been doing over Zoom. Joel and I gave a presentation to JPs at the Texas Justice Courts Training Center on magistration, and I gave a presentation to the Texas Association of Counties Fall Judicial Education Program on indigent defense. You'll also see some committee work I've been doing. I represent TIDC in the Office of Court Administration before the State Behavioral Health Coordinating Council. I've been doing quite a bit of work with them. They are developing their strategic plan for the next 5 years. And wanted to make sure y'all knew about a great new publication that we have out, authored by Claire Buteau on Public Defender Primer. And so we'll be using that to further promote public defenders and help counties establish them. That's about all I got.
Judge, if I could brag on Scott and Kathleen just real quick.
Sure.
All of the public defender offices and managed assigned counsel systems that this board has approved in the past few years, if you think about the Hill Country Public Defender, Galveston Public Defender, Harris County Managed Assigned Counsel, Travis County Managed Assigned Counsel, McLennan County Managed Assigned Counsel, Travis County Public Defender, Harris County Managed Assigned Counsel, all of that, none of those would exist without the really good work that Scott and Kathleen have been doing. So I'm just grateful for all they're doing.
Well, all of us are grateful, so thank you both. Thanks, Jeff. All right, next is grants and reporting.
I'll get started with that part, Judge. Thank you. If I could direct you all, good afternoon, everyone. Direct you to page 12 of your meeting materials. We have a preliminary report on the results of the indigent defense expenditure reports that were submitted for last fiscal year. I do want to emphasize preliminary at this point because this year we have had some counties that have had trouble getting their reports completed and into us. A lot of that is COVID-19 related, and just talked to an auditor who was out for a couple of weeks after having been sick. So we are getting the data, but there's still some gaps. So the data is going to be preliminary, and that will also impact the preliminary formula grant awards that we'll talk about in a little while. But the big news is that COVID-19 has substantially impacted or reduced county spending on indigent defense in FY20. So in FY19, the total county spending was just under $300 million total. We're looking at approximately $262.6 million for FY20. So that's down somewhere in the neighborhood of $37 million, or about 12.5%. As you all will recall, we've been seeing a steady increase in spending by counties on indigent defense, pretty much going back to when the commission was established. And so this is quite remarkable. We haven't seen anything like it, but we do fully understand that the main driver to this big dip is that courts have been shut down or slowed down dramatically. So very few cases have been processed, and very few attorneys who have been paid for those cases that would have been completed. So we anticipate that the drop is temporary, and the overwhelming majority of it is related to impacts of COVID-19. So we're going to continue as we get the data finalized. I should note that the staff collaborates to do a desk review of all 254 reports that are submitted by the counties to make sure that we can catch a number of errors. I mean, it's not perfect data, but we do really increase the value and reliability of the data based on those desk reviews. They're still in progress. We've made a lot of progress reviewing them, but we still have some to go. So we're going to be finalizing these numbers, but I don't think things are going to change dramatically, and we will kind of lock in that decrease in spending. So you can see some additional details there on page 12 if you'd like, and a graph that kind of contextualizes the decline in spending. Next, I would refer you to the following page. I just lost my place, I'm sorry. So on page 14, we'll start with the budget reports. Page 14, you'll see the status of our previous budget years that remain open. This sheet shows the current balance in each year for the current balance in each budget year, recent grant payments, and pending grant obligations for both FY19 and FY20. We do still have significant pending grant obligations in each of those fiscal years, and the unobligated funds from these years will be necessary to be carried forward to cover existing grant commitments in 2021. Perhaps more interesting this year than in most years is page 15, which is our revenue flow comparison sheet that we share with you at each meeting. I want to note that this morning we sent you some supplemental materials, including a replacement to this page, because we did catch an error in the historical data for juror pay revenue in FY19. So if you want to refer to the corrected page that was submitted via email, we can, that had one small error that was corrected. But the main takeaways as we look at the revenue comparison that I want to draw your attention to, the court cost revenue dropped from $34.3 million in 2019 to $29.1 million in 2020. So that's court costs that flow into the fair defense account. So a significant drop in court cost revenue, again, that we anticipate is almost, well, very largely due to COVID-19 and the decline in cases paid as a result of delays and reductions in cases related to the COVID. Surety bond fees were down nominally from 1.9 million to 1.6 million last year, and state bar collections were down from 2.4 million to 2.2 million. So much more modest declines on those other more minor sources of funds for the fair defense account, but we did see a huge impact in court cost revenue. Our juror pay fee court cost revenue was largely flat at 5.9 million compared to last year. We're already seeing some improvement in collections of court costs flowing into the fair defense account, and it's very difficult to project things, but we are seeing positive trends, and it looks like we're, we can see the light at the end of the tunnel. So despite the fact that the funds flowing into the Fair Defense account have declined substantially due to COVID-19, the good news is that the balance of the Fair Defense account has in recent years substantially exceeded the amount that the legislature has given us the authority to spend. And so that has resulted in a kind of reserve fund balance in the Fair Defense account. And based on our analysis, we are confident that the reserve balance that's accumulated in the Fair Defense account will offset the decline in revenues related to COVID-19. We do still have a very long running trend of lower court cost collections that has to do with changes in prosecution policies regarding marijuana, for example. It has to do with decline in traffic offenses and things like that generate fees for the Fair Defense account. But we do have those long-term trends that are still there, and in the long run, we will need to revisit the sources of funding for the Fair Defense account. But in terms of the impact of COVID-19, that should be offset by the accumulated fund balance from recent years. Finally, on page 16, we just have a budget activity status report. There's been very little budget activity in the first few months of the year, just administrative expenses as we get up and running for FY21. So that concludes the budget reports. Are there any questions before we move on to formula grants?
Do you happen to remember what the court costs were in 2018? They went down in 2019 to 34 million. Do you remember what they were in 2018?
In 2018, we could, Sharon may be able to pull that up. Sharon, do you know what court costs were in 2018? We kind of let those years drop off as we look at our 3-year window.
That's okay. That's okay. I just wondered how much it was going down.
Yeah, the long term, I mean, we had been seeing kind of in terms of that underlying trend, we've been seeing declines in court cost collections that were, a few percent, 5%, I want to say, roughly in that neighborhood, year over year. Thank you.
That's my recollection too. I think it was several years running. We've seen 2%, 3%, but I don't think any more than 5% at any one time. But so it doesn't really constitute a crisis, but over time, it's a little bit concerning.
Yeah, there's a gradual erosion of our revenue sources there because of.
I was going to say for Judge Keller, you were asking about FY18. For FY18, court cost was $34,743,124. So it was about the same as it was for 19.
Okay, thanks very much.
Yeah, fairly minor decline that year over year.
Right.
Okay. Any other questions? We can proceed to the next item, which is formula grant awards. I'm going to hand it over to Doriana Torres to lay out that. You can go to page 17 of your meeting book.
Thank you, Edwin. So our next item is an update on the formula grant program. This morning, the grants team distributed supplemental materials via email that included an estimated formula grant award amounts and an overview sheet titled FY21 Formula Grant Preliminary Estimates, and that's what I'll be referring to in this report. At the August meeting, the Commission adopted the fiscal year 2021 formula grant request for applications and a $22 million budget. So there are no changes to that formula that determines the award amount, and the estimated awards for 75% of our counties are above the 2019 levels. As Edwin mentioned earlier, county spending was down significantly statewide in FY20 due to decreases in indigent cases paid associated with the FY19 pandemic. Oh, thank you, Megan. And so under current policy, counties must spend above their year 2000 baseline expenditures to be eligible for the formula grant program. And the Commission has also permanently waived the baseline requirements for counties that had a population below 10,000 in the year 2000, the baseline year. So our preliminary calculations indicate that there are 6 counties that would not qualify for the formula grant program in FY21 because the county spent less than their baseline spending. And a few additional counties would also have their awards reduced because the maximum award is capped at the amount of their baseline. And so I believe there's a motion to award the FY 2021 formula grant according to the policy that was published in the FY 2021 formula grant RFA, with the exception of waiving the baseline requirements. It's likely that the significant drops in spending that would make these counties ineligible are temporary and related to the COVID-19 pandemic right now.
Okay, is there a motion to do what Brianna just said? Do you understand what we're doing? We're adopting, the only thing we're accepting out is we're going to waive the requirement that the expenditures be over the baseline this year.
Correct.
Right.
So moved.
Is there a second?
I'll
Any
second the
discussion?
motion.
Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Okay, thanks. The motion carries.
Awesome. All right, so if we'll go back to our meeting book on page 18, I'll give a quick update on our special conditions. So when formula grants are awarded, there are special conditions placed on these awards to counties that are not in compliance with either plan, reporting, or grant requirements. So the numbers in your book were up to date once we sent up the meeting materials, but they have changed. So I'm going to report on some updated numbers. So as of this morning, there are 21 counties that have not fully completed their approval process for the Indigent Defense Plan submission. And I believe our policy team will touch on that later on. There are 25 counties that still have outstanding commissioners' courts resolutions, 8 counties that have outstanding IDERs, and we are waiting for final numbers from the Office of Court Administration regarding Judicial Council reporting compliance. And I do want to note that the number of counties with special conditions is in line with our previous years, and it looks like COVID has not greatly affected these processes. And I think that's it, if there are any questions.
Thank you, Doriana. So yeah, so we're continuing, those counties that will have a hold on their formula grant funding, we're continuing to reach out to them. A number of us on staff have been making phone calls and addressing these outstanding matters, and we anticipate resolving most of them in the near future. The next item on the agenda is regarding the FY 2022 Improvement Grant request for applications. So if you can turn to your meeting book, page 19. Each year we issue the RFA, the request for applications for the Improvement Grant Program, which has all the rules and application procedures for how counties can access those funds. The RFA has been updated with all the dates for the FY 2022 cycle, and a full draft is included in the meeting book following this page. In addition to the edits for clarity and dates, of course, we are recommending a handful of substantive changes that I just want to bring to your attention. First of all, we have operated the Technical Support Grant Program historically as a sort of an entirely separate application process off to the side of our standard Competitive Improvement Grant Program. And so we're proposing to kind of incorporate the Technical Support Grant application process into the same process followed by applicants in the Competitive Improvement Grant Program. Technical support grants are focused on special projects such as indigent defense research, program evaluations, or specialized pilot projects. We think that this change simply will simplify the application process and for counties and for us. And there aren't any real substantive changes to how those funds would be awarded beyond making the application process uniform. I do want to mention that one of the reasons that this recommendation works for us now is because we last year changed the deadline for the Improvement Grant Program from a very hard deadline to a priority deadline. So any application that comes in beyond or after the priority deadline in May can still be considered and presented to the Commission for a grant. And we will continue to budget for those specialized technical support programs separately from the regular improvement grant program. So that's the first substantive recommended change. Next, we're proposing some additional application requirements for counties seeking grants for public defender or managed assigned counsel programs. Particularly in this most recent cycle, we've run into some delays with counties getting up and running because they haven't really spent much time in the application process focused on their oversight boards, how they're going to hire the chief public defender or managed assigned counsel director. A lot of those kinds of things that are first steps in getting a new program up and running there hasn't been much time spent on them prior to an award. So we're proposing to ask counties that are asking for those types of grants to just include in their grant application their plans for an oversight board, as well as their plans for recruiting the leadership for the program, the chief public defender or managing attorney in a MAC, as well as, and just make that a part of the application. The staff has prepared some template documents that can get counties started. So we don't think that it's going to be terribly burdensome for counties to think about this early in the application process. And those template documents, including a program leadership recruitment rubric, are included just as resources for counties. They don't have to use those, but they're just offered as resources for counties to do this. We think that it will help to avoid delays in new programs getting up and running. Finally, two more quick ones. We're proposing to eliminate a formal requirement that was in the RFA previously to involve the local defense bar in planning for public defender offices. We definitely think that it's essential for counties to reach out to all the stakeholders as they're making any plans along these lines. But we were kind of unclear when we got some questions about how to document or what exactly that meant in practice in terms of it being a formal requirement for counties to proceed in an application. So because of that, we think it's just simpler to eliminate that as a formal requirement. Of course, we will still continue to encourage communication with all the stakeholders in the county whenever a county is contemplating applying for a grant like this. But that's a kind of, I think, minor simplification. And then lastly, we do want to add the expectation, we've had an expectation that we add as a standard grant condition that for counties that get a public defender or managed assigned counsel program, that they need to have an oversight board that meets at least quarterly to provide a venue to consider how the program's doing, to get feedback from the stakeholders, et cetera. We just want to make that expectation clear at the outset for counties that are applying, instead of perhaps just learning about it when they get an award. Those are the only substantive recommendations that we're offering.
You mind if I jump in real quick? And I want to apologize to Judge Keller. We spoke earlier, and I think I was misunderstanding what you had mentioned. And I think that I forget with the very last item about quarterly meetings, I think you'd asked about, can they meet a little bit less often? And I misremembered thinking that was later in the document as part of kind of the templates, and forgot that it was a requirement. So I don't know if you want to speak to that. And I apologize for my miscommunication on that.
That's okay. Yeah, I did. I thought, I don't know that public defender oversight boards all need to meet quarterly. And I thought it might depend on how small the board is or how big the office is. I don't know, but I thought it might be better to make the requirement for 2 times maybe, and say at least 2 times a year. But I don't know how these things work. So Alex, in Harris County, how often does the oversight board meet?
Well, we had been meeting quarterly. I have to say, because of COVID, we're behind. So I'm due to have a meeting, but yeah, traditionally it's been quarterly here.
What do you think? Who knows about the smaller PD offices? Is there anybody with any knowledge of their oversight board?
I've attended a number of them in South Texas. I think they try to meet quarterly. I think you make a good point, Judge, that maybe the frequency, maybe the required frequency could be less, but a recommendation could be at least 4 times a year.
Yeah, I think I would prefer that and leave them a little flexibility, and then Alex, you wouldn't be behind.
Yeah, that would be good for me.
I think our thinking is that we want to make sure that we encourage, one of the reasons that oversight boards are important is that they create a sort of formal venue in which to check in, talk about any issues, gather feedback, make sure stakeholders are apprised of what's going on. So that's really what we're after. But I think your suggestion is entirely consistent with that.
Well, then should we say something like at least 2 times a year, but preferably quarterly?
Yeah,
Just leave it
we recommend quarterly, but at a minimum twice a year or something.
Okay, is everybody okay with that?
Yes.
Sounds good.
Okay. Thank you.
Very good. Thank you, Judge. So I believe we have a motion, and we can amend the motion to include the change that we just discussed.
I did have a question.
Yeah, go ahead.
I'm down here thank you, Judge. I'm on the bottom of page 19 down here, and it talks about how it's unclear how to document compliance with this requirement concerning consultation with a local defense bar and planning a public defender office. I understand it would be I think there's some difficulty in trying to document that. Who do you talk to in connection with a bar? What does it mean to actually have the discussion with them and that sort of thing? However, I'm worried that what's going to happen is that eventually we're just going to leave out the defense bar altogether in connection with this planning. And so I'm kind of struggling with how it is that we might still emphasize that it's important that they're included and that their thoughts about this are included. Do you have any thoughts about it?
I can speak to that a little bit. Cause I think you're right. I mean, I think the way this concern came up is exactly the way you laid it out, that especially in rural areas, where you don't really always have an organized defense bar, what does it mean to get that approval? And so we really played with that. So maybe there's a way to, instead of entire elimination, to still encourage meeting with the defense bar, but drop the formal requirement that there be some sort of approval.
Yeah, I just think that, if there were any teeth at all that you could put into it, because just from the ground level, the defense bar already feels like it's under attack sometimes whenever these public defender offices are proposed. It certainly does have a big impact economically on the quality of on the defense bar, which in turn has an impact on the quality of your bar. And so I think, it just would bode well in terms of the community getting behind the idea of this public defender's office if there was something more stringent about consulting with a defense bar. And of course, Jeff, you can always make the argument, well, we know what they're going to say. However, I do think there's input about the nature of the community that you miss and the environment in which that office is going to sit if you do not consult with those things.
Yeah, I agree 100%. I think it's a practical matter. We've never been in an area where TIDC hasn't personally consulted with the defense bar, and we've really encouraged commissioners and judges to do the same. So yeah, I understand that completely, and I agree. I think our concern with, we had counties just kind of saying, well, what does this actually mean, this requirement? We don't really have an organized defense bar, so how do we meet that? But Edwin, do you have a suggestion? Because I think this point's well taken. Do you have a suggestion on how to rework that based on that?
I mean, I think right now it's listed as a required program element. The consultation with the defense bar is a quote unquote required program element. I think that we can certainly leave it in because I think Representative Smith makes a good point. I think the reason that we proposed eliminating it as a formal requirement was because we were a little unclear ourselves about, as you said, how to document it or what it meant in different, particularly rural contexts. Is it enough to just talk to one lawyer, in the courthouse for a few minutes or not? So I think we could leave it there and just provide a little more contextual, context-sensitive guidance to counties as we're going. Beyond that, I'm not exactly sure what to do.
Well, and I don't want to talk too much, but to the extent that they're organized, right? I mean, like you're saying, some of these rural counties, the guy may be coming from 2 counties over to a particular county to practice. In Grayson County, for instance, we have a bar, the Grayson County Bar Association. And I think many counties do. And most of your defense lawyers are going to either frequent those meetings or belong technically. So anyway, I'm just throwing that out there. I just hate for us to leave these guys behind.
I take your point. I think we could change it to specifically reference a local bar association, if any.
I think that's a good compromise.
Okay. Other discussion?
Thank you.
Thank you, Representative. Okay, well, so we do have a motion, and I guess we have two amendments on the table.
I don't think I have I don't know where the motions are, so I'm just allowing you to say what they are, but is there a motion to?
So we have, let me pull up my motion.
They're there, okay.
Okay, so we have a motion to adopt and issue the FY 2022 improvement grant request for applications with two amendments that have just been discussed. The first being, I'm just trying to synthesize this, regarding quarterly meetings for oversight boards to recommend quarterly, but require at least twice per year. And the second change to what was proposed would be to continue to have a formal requirement for PDs and MACs, for counties applying for PDs and MACs, to consult the local Defense Bar Association, if any.
Okay, is there a motion?
So moved.
I'll make the motion.
Okay, is there a second? Any discussion?
Second.
All in favor?
Aye.
Aye.
Opposed? Okay, thank you. Motion carries.
Thank you all. That's it for our grant. Oh, we do have one additional grant modification request matter. If I could direct you to get to the right page here, bear with me.
Edwin, this is the RPD related?
Yes.
While you're looking it up, I'll just kind of tee it up for everybody.
Oh, I found it. Okay, it's on page 46. Direct your attention to page 46. And Jeff, you're welcome to introduce the background if you'd like.
Sure. I think pretty much everybody here should be familiar with the Regional Public Capital cases. It's been around a little bit over a decade now and provides death penalty trial level representation in close to, well, gosh, we're over 180 counties now. I think it's 185 counties. It's opt-in, so it's voluntary for all the counties. By rule, it excludes the largest 14 counties, but any other county beyond that, so the other 240 are eligible. And as I mentioned, 185 have opted in. It started, it has been for the past decade, a Lubbock County agency. And, the good news is it's been very successful. The bad news, I think, for both us and Lubbock County is it's become kind of unwieldy to manage as a county agency when you're covering 185 counties. You can imagine the problems with having 6 different offices across the state and the benefits for those employees working out of county and living out of county and things like that. So we worked with Jim Allison. I think we reported on this maybe 2 meetings ago. We worked with Jim Allison to help develop a local government corporation for our PDO. We tried essentially to have as few moving parts as possible. So board composition is pretty much the same. The staffing is pretty much the same. Their delivery services are pretty much the same. The division of the funding between state and county is the same. Really, we're just trying to create this entity that makes it a little bit more sustainable. So the motion today is essentially to, once the clock will strike midnight on December 31st, and we'll switch over from the current RPDO entity to funding the new local government corporation. In the meantime, I mentioned that all the counties have been made aware of it. and letters have already gone out to the counties, and the counties are already signing the new interlocal government corporation agreements for the new RPDO. So it should be an easy transition, but we do need formal approval just to make sure we can continue funding RPDO after the transition.
I'd like to say a hearty thanks to Lubbock County.
They've gone above and beyond, Justice
A
Raddatz.
very hearty thanks to them.
They have in so many ways to getting it started in the first place. Okay, is there a motion? Is there a motion on this, Jeff?
So moved.
I can read the motion. It's, if I may, it's a motion to terminate the sustainability grant to Lubbock County for the Regional Public Defender Office for Capital Cases and replace it with a new grant to the RPDO Local Government Corporation for the unexpended balance of the grant upon formal request of Lubbock County and the RPDO Board of Directors.
Okay, there's a motion. Is there a second?
Second.
Any discussion? All in favor?
Aye.
Aye.
Any opposed? Okay, thanks. The motion carries.
Thank you all. That concludes the grant-related matters on our agenda. I believe we have fiscal monitoring next.
And real quick, I would just echo what Chief Justice Raddatz said. I've served on the board for RPDO and seen up close for years that the amount of work that their commissioners and county judge have put into this office has been really impressive. And they'll continue to be involved in it, but hopefully this eases their burden a little bit.
Good. Okay, thank you, Edwin.
Thank you.
Who's next?
That would be me, fiscal monitoring.
Hi. Okay, go ahead. Thanks.
I'd like to turn to page 47. From 47 to page 50, I've highlighted the activity for the new year. I've begun one additional review and I've issued 2 final reports and 2 initial reports, and I've got another 4 reports actually being vetted and a pending issue at this time. The 2 final reports were to Irion and Moore County. The 2 initial reports are San Jacinto and Clayburgh County. Other activities, I look at the comprehensive annual financial reports that counties submit. So the single audits and CAFRs, I call those. I've had 2 counties submit those. Those were San Jacinto and Harris County. So I reviewed those. And then we had our annual desk review, and I've reviewed over 60 counties at this point. So that's pretty much the activity of this quarter. But I do have one financial issue. So on page 51, Clayburgh County, Judge Keller asked me to bring it to your attention. We usually, when I have a financial issue, it's usually an over-reporting issue, but this time we had a county under-report some expenses. And Clayburgh County underreported $15,000 this last time. I think that it was an error and an oversight that this occurred, but it did happen. Looking at what it would have done to the formula grant, we actually would have given them $560 more. So at this point, the staff does not recommend making any adjustment, but I think we wanted to bring the issue to the full board and have a discussion. As I say this, I know I haven't ever brought underreporting before, but I do have a couple more counties that have underreported, and one of them, they're going to be significant in my mind. So maybe it's a discussion we should have now, because it's going to be coming up probably next quarter.
Deborah, can I just, let me just briefly say that the reason this is relevant, and just to remind folks, since I know we have some members who aren't long haulers, our formula grant funding is based 50% on population and 50% on reported expenditure, eligible expenditures. So when a county underreports on their IDER, it might lead to lower formula grant funding.
And I think what we do, if somebody over-reports, if it's going to be a lot of work to make an adjustment, I think we put it, is it at $500, Deborah? That,
I believe, yeah, I believe we're close to 500, but I think
okay,
it's like case basis.
Okay, so anything around $500 or less, we're not going to go to the trouble of making the changes. And I think we should do the same thing for underreporting, and we shouldn't put staff to the work of fixing this. But I also think we've talked about this, and they will come back to us if, well, with each time, I guess. But if there's a bigger amount that they've underreported, we might want to consider making an adjustment. We don't want to encourage counties to count on us for this, but we want to keep the ability to make an adjustment if we need to. And I think that's where we stand. Does that sound right?
I believe so.
Okay, thanks, Deborah.
Yeah.
Deborah, do you need us to, I mean, Clayburg's in the 5th region. Do you need me to reach out to anybody in Clayburg at all to fix this or do anything for you?
I think we're okay here. I think it was just an error and they're aware of it. So they'll be taking care of it as we go forward. So, yeah. Any other questions? Okay, that's the end of my report.
Thank you, Deborah.
Thank you.
Next, are we to policies and standards?
Yes, that would, if you could please turn to page 52, and unless Alex prefers something else. Could I go ahead?
No, Joe, I'm just going to introduce you. Go ahead.
Okay, thank you. On page 52, we have a summary of our indigent defense plan submission and review process. Every 2 years, counties have to submit their indigent defense plans. As of November 1st, 2019, that was the last deadline. And as of the August meeting, we'd finally gotten all counties to submit their indigent defense plans. Staff are currently reviewing plans to make sure they meet relevant statutory requirements and administrative requirements. At the time I put this book together, there were 25 counties that had not yet met all those requirements. That number is down to 21 counties. Staff has been in regular contact with the remaining counties, and we hope we're very close to knocking this number down to 0, or at least very close to 0. But until the counties meet all of the plan requirements, they will have a formula grant hold. And so with that, if there are no questions, if you could please turn to page 53. I want to now talk about some indigent defense statistics, and I want to emphasize that these are preliminary totals. And I want to begin by talking about caseloads. So in 2013, the legislature directed TIDC to fund a study to examine the maximum caseloads that an attorney could reasonably handle. This study was conducted by the Public Policy Research Institute at Texas A&M, and they actually had a couple follow-up studies. And what they determined was that with a mixed felony or misdemeanor caseload, for an attorney without a staff investigator, they felt that the maximum number would be about 128 felony cases, 226 misdemeanor cases, or 31 appeals cases in a year. And so now every year, auditors and treasurers must report the number of cases for which attorneys are paid and the amount that they're paid, so we can compare these two numbers. This last year, most attorneys were well below the guidelines suggested by PPRI. The median caseload, or median appointed caseload, was 28% of the weighted caseload guidelines. Some attorneys exceeded that number. About 10% of all attorneys receiving appointments exceeded it. Some exceeded it by a large amount. One attorney had 5 times the recommended guidelines, and 25 attorneys had 3 times the recommended guidelines. While there were some attorneys that did exceed this amount, it was a lower number than last year. Attorneys must also report the percent of their practice time. So we know from auditors and treasurers the amounts that are charged for indigent defense work, but we do not know the percent of practice time devoted to other things. So attorneys are required to report this annually. We have trouble gathering this report from attorneys, but as of November 18th, about 2/3 of those attorneys who had received the payment had also submitted a practice time report. TIDC works with other groups. For instance, TCDLA reminds attorneys to submit reports, and the Public Policy Research Institute, they send out an emailing telling counties who is probably reported and who does not appear to have reported, so that counties can remind attorneys on their lists to go out and report to us. But I think there's two things to glean from the report. First, about 95% of attorneys that take appointments practice in more than one county. And the second is that about 65% of their work has been devoted to indigent defense. That's a median level. So if we compare these two numbers, first, that about the median appointed caseload level was 28% of the weighted caseload guidelines, and second, that the median percent of a practice time devoted to indigent defense was 65% of an attorney's practice time, I think we can glean that most attorneys do not have a caseload problem, but we clearly do have some that do. And so if you could please turn to page 54, every year I put together a table showing those attorneys that were at least 4 times the weighted caseload guidelines. This last year, there were 7 attorneys, and I have a table. There's some highlighted attorneys. Those attorneys were on the list for both 2019 and 2020. So all 7 of these attorneys were from the Dallas County Public Defender's Office. It was good, however, that there were 7 attorneys this year, and last year it looks like there were close to 20. So we've seen some improvement on that front. As far as attorney payments, if you could please turn to page 55. Most attorneys do not get rich on court appointments. The median amount paid to appointed attorneys last year was about $18,500. Some attorneys did very well. Every year I put together a table showing those attorneys that made at least $300,000 on appointments. And there were 20 attorneys this year. The highlighted names were on both the 2019 list and the 2020 list. The top attorney this year made over $750,000 on appointments. And this is the highest amount I've ever seen. And it doesn't appear to be a one-time thing where maybe some big cases came in that paid out, because this attorney was also on the list last year and made $470,000. And so I don't have any more comments except that it's a lot of money. So if we could going forward to another statistic, please turn to page 57. And I want to talk about appointment rates. TIDC has changed the way we track appointment rates. We currently now use cases paid. That's a case that has been paid for an appointment, and it's usually happens when the case is disposed. And we compare that now to cases disposed in the same fiscal year. Previously, we compared this to new cases added, and there was a 1-month difference between when the cases were paid and from when the cases were added. So it wasn't an apples to apples comparison, and the new measure is much more of an apples to apples comparison. Over time, appointment rates have gone up. This last year, the felony appointment rates went up to 87% of felony cases appeared to have appointed counsel. I'd like to say, however, that is very preliminary. Both our numbers and OCA's numbers may change. If it does stay, I would say it happened. It has some relation to COVID, but this is the highest it's ever been. As far as misdemeanors, about 48% of misdemeanor cases had appointed counsel.
Joel, if we could pause real quick. Commissioner Covey, you just used that raise your hand function. So Commissioner, I didn't know if you had a question or not, but I thought I'd pause just to make sure. Commissioner Covey, can you hear us? Okay, may have just been an accident.
Thanks. I didn't notice anything. Sorry, Jeff. If we could go forward to the page 58 then. Every year now we try to track and make an estimate of the number of cases without counsel in misdemeanor cases. Since we've been able to track this estimate, the percent of cases without counsel has decreased significantly. This last year, about 23% of misdemeanor cases went without counsel. The one point I would like to emphasize here is that the number of cases without counsel is much higher in small counties than in large counties. In large counties, very few people go without counsel. and in small counties, a large number of cases go without counsel. So with that, let's turn over to some recent policy monitoring activity, unless anyone has questions about those statistics. I'm sorry, I kind of went through those very fast.
Can you hear me okay?
Yes, Commissioner.
Yeah, I was just curious on Jimmy Joe Ortiz, I believe is his name, if I can pull it back up, making
Yes,
over
correct.
$750,000. But he wasn't on the list with most cases. I didn't see him.
That's correct.
So what did you say the reason for that would be?
Well, this year he was paid for, I believe, 3 capital murder cases, but as far as why he got paid as much as he did, that's kind of an open question. All of his cases were from Harris County. It looks like he got paid a lot per case, but I don't know. I don't know as far as individual cases, what has happened.
So it may just be that he had a difficult case that caused it to be a high amount, capital murder or something.
Well, except that last year he didn't have any capital murder cases and he still came out with $470,000.
So is that something that you look into, or I mean, is there anything, I mean, not that there'd be anything nefarious, but just, is that something that we look into?
To some extent, on the fiscal review side, we would look into it. On the policy side, I don't know that we have a standard as to an appropriate amount of pay per case, but it's something that we collect, and I think it's something that the board should be apprised of.
And it's on our website, right?
That's correct.
But I don't think we do anything about it except just gather the data and then put it on the website so everybody can see what's going on.
Yeah, it's really up to the judges, I believe, to set the amounts per attorney, the attorney fees, right? And as long as it's within that approved schedule, then it's not a problem. Is that true, Judge?
I think that's true, but more than that, unless someone complains, it's not a problem, and I don't know who would complain.
I'm not sure who would know unless they
Right.
look, but other attorneys, I guess, would then look at our website and see this information, and that's how they would know, probably.
Alex, do you have any input on this?
That's the first time I've seen that number. And usually there's somebody at about 500,000, but it's usually based on volume, not that few cases. So I might take a look and see. I mean, me personally, I may take a look and see, but it's probably based on the 3 capital cases, not the 200 and something felonies, because it's unusual for judges to go much higher on non-capital cases.
That's a lot for 3 capital cases, depending on where he is in the process too.
Yeah. Yep.
Well, Alex, if you find out anything, you can let us know. Okay.
Thank you.
We'll pull the vouchers and take a look.
Okay.
Thanks. I appreciate it. Thank you.
With that said, I guess I'll continue on to page 59 for a summary of our recent policy monitoring activity. So since the last August meeting, we've issued 1 grant report for the Regional Star Public Defender Office, and this was more than a grant report. It looked a little bit into methods for requesting and receiving appointed counsel. We also received a response to a monitoring report that we had issued in July from Deaf Smith County. We have 3 virtual monitoring reviews ongoing in Harris, Montgomery, and Parker counties, and we're just about to start virtual reviews in Williamson, Tom Green, and Brazoria counties. Going forward to page 60, last year we talked about starting a quality metric pilot. Over the last year, we've done a handful of reviews with the quality metrics, not a lot yet. These are supplements to our monitoring reports. They do not contain monitoring findings, but they try to look at certain quality indicators, for instance, defense caseloads, use of investigators, and attorney-client contacts. For larger counties, we try to include a criminal defense survey. And we don't have any clear observations, except that as a preliminary matter, it seems that the courts have had issues systematically monitoring those quality indicators. Going forward now, to conclude my report, on pages 61 through I think 64, I have a little summary of our risk assessment. Every January, I run a risk assessment based on the numbers that we collect over the year. And this lists the factors and how we determine our visits based on the risk assessment. If there's any questions, I'm happy to answer them. But if not, I will turn this over to Lindsay, who will talk about complaints. Thank you.
Lindsay, before you do, I would add just one more thing to Joel's report about the quality metrics pilot. We had hoped pre-COVID that we would pilot this for a year and then be able to bring it to the board and say it's been successful or it's not been successful, and we should incorporate this aspect of it or not. Really, just because of COVID, Joel and Lindsay and Claire and Wesley have done an excellent job monitoring under very tricky circumstances. All of our monitoring right now is remote. But we just don't feel like we have enough counties that we've really done this quality metrics pilot in. So we plan to continue that. We don't have any requests for the board right now, but we will keep you posted on that and let you know how it goes.
Okay, thanks, Joel. Lindsay, next.
Thank you, Judge. Beginning on page 65 in your meeting book is a summary of recent complaints. 26 complaints have been received since the August 27th board meeting. 22 require no further action. 8 complaints have been forwarded to local officials. 19 complainants have been referred to the state bar. 14 to other outside entities. 5 to Innocence Projects, and 2 to self-service legal resources. We received 18 complaints from defendants and a concerned citizen in Lubbock County concerning representation of court-appointed counsel. Some complainants also indicate that the Lubbock Private Defender's Office has not addressed their complaints to their satisfaction. These complaints were forwarded on to the Lubbock Private Defender's Office, and leadership responded indicating that the complaints would be investigated and the attorneys and clients would be notified. Each complainant with an active case was also referred to the State Bar's Client Attorney Assistance Program. A second relevant complaint, following a previous letter regarding an innocence claim out of Dallas County, Mr. Juan Lopez wrote to TIDC to express his belief that there are hundreds of people incarcerated in Texas due to ineffective assistance of counsel, which he believes is correlated with the representation of court-appointed counsel. Mr. Lopez expressed that there are inadequate remedies in the appellate courts and with the state bar, and he believes that there should be oversight and management of attorneys by a public defender or an independent body at the outset in order to avoid performance issues leading to such outcomes. Mr. Lopez's letter will receive a response. The third relevant complaint, following previous complaints and referrals, Mr. Norman Yos, who has a pending case out of Bandera County, wrote to TIDC indicating that he wanted to notify us, pursuant to his understanding of our responsibilities related to appointing and funding court-appointed counsel, that he believes his attorney lied to the state bar regarding the number of times that he was visited. He expresses his frustration with the fact that he is unable to subpoena the jail video to corroborate the facts as he sees them, and he asks us if we can assist with this. Mr. Yos's judge and defense attorney were notified of the most recent and of his previous complaints, and Mr. Yos will also receive a response. That concludes my report.
That's all
Any
for
questions?
policy and standards.
Okay, thank you, Lindsay, and thank you, Alex. Next thing on the agenda is mission, vision, and values. Is that you, Jeff?
Yes, Judge. And I think this is the last thing that we have for today. So we're buzzing through stuff today. I was going to talk about this for a little bit, and then Judge, I believe you had a related note to bring up after that. So a lot of us, we had the good fortune to go to pre-COVID again, a leadership training for indigent defense leaders. And one of the speakers, who was just excellent, brought up the subject of mission, vision, values, and asked the audience, how many of you can recite what your mission is? The thing that's supposed to be driving what you do every day. And no one in the audience could. How many people can paraphrase what your mission is? And very, very few could. And the emphasis really was on paring down your mission, making it clear, making it succinct, and making it something that actually does drive what you do on a daily basis. Mission, essentially, this is, again, what you do every day. The vision is, if you're successful, where do you end up? And then the values are really the things that I think for us internally as staff, we really measure ourselves against. So the mission that we're recommending, of course, with any tweaks by the board, is protecting the right to counsel, improving public defense. The vision, again, where we'd like to end up, is excellent representation for all. And the values, as you can see, and we add definitions for these so that we're trying to be specific and concrete, are accountability, continuous improvement, collaboration, empathy, integrity, and fairness. And again, those values are things that we really want to judge our own behavior as staff on a daily basis. So we thought we'd bring these to the board. And Judge, I know you had, again, a related note about TIDC historically.
I did. Thanks, Jeff. When we started talking about mission, vision, and values, I realized that there are a couple of guiding principles that have been in existence since the Indigent Defense Commission was the task force. And I thought, if we're going to adopt mission, vision, and values, this is the time to talk about two things, because I don't want them to get lost as some of our guiding principles. And the first one is deferring to local control. So when we started out, we realized that not only were we not giving the counties enough money to make them want to cooperate with us, but local counties, generally, we believe, know what's going on locally better than we do, and know or can come up with solutions better than we can as a statewide entity. And a couple of examples I want to give. The best one is the RPDO that Jeff was talking about earlier. It came about because of David Slayton when he was still working in Lubbock, and a couple of the regional PJs up in the Panhandle. And they realized that we needed capital representation in rural counties. And they got together and got it done. And now I think there are 185 counties that are involved statewide. That would never have happened if we had been telling them what to do, because they're the ones that came up with the idea. And then David's the one that went to all the county commissioners in the different, I think initially 80 counties, and got them to sign on to this. So the idea and the energy and the creation of the RPDO is the best example I can think of letting local counties drive the train. Another example is, I can't remember what county was, some county down on the border had way too many people in jail waiting for trial. And one of the judges came to us and he said, we need help with this. And we talked it over and created a strike force of attorneys to get these people represented, and gave them extra money and get them out of jail, to get the jail population down to a manageable number that could be sustained. And again, that was because one of the local judges said, we've got a problem and we need your help, not us saying, you've got too many people in jail and you need to fix it. So that was the first principle. The second one is something that I think all agencies ought to do, but we've done it. And that is to be proactive in trying to restrict the burdens that we put on counties. Because it's real easy for us to tell counties, this is what you have to do, and fill out all this paperwork and go through all these procedures and processes, because they're doing it, not us. And it takes an effort, it takes a conscious effort to not burden the counties. But I think that's one of our guiding principles too. And by that, I mean, these are the two principles that we look at everything, every act we do should have these two things in mind. And we do this, but I don't think we've recognized it in a long time. So one example is, we used to have a yearly reporting requirement. Was it for the IDER? I don't remember what it was, but the staff just recommended making it every 2 years, a report instead of every year. And then they put it on the computer so you could do it really fast. And that's one example of trying to help the counties do what we want them to do and reduce the burden. Another one we saw today is templates. We have been doing templates forever, and we don't say, here's what you have to do. We say, here's a template, use it if you want, do your own thing if you want. But most people use the templates because they're helpful. So while we're considering adopting mission, vision, and values, I want to suggest that we also adopt these two guiding principles, which would be briefly stated as, well, I wrote it down somewhere. Principle number 1 is that we defer to local counties when possible. Principle number 2 is that we be aware of and try to reduce the burdens that we place on counties when we can. What do y'all think? Okay.
I fully support.
Okay, thanks, Jed.
I do too. I think that's the best way to do it.
I think as a county judge is great.
I read something today on the internet. I was reading about, looking at some people that are running for in a runoff here. And one of the quotes from, I don't remember who, said, people support solutions they help create. And that's kind of the idea behind principle number 1. Okay, well, is there anybody who, well, can we add those then? Do we have a motion, Jeff?
We do, Judge.
Okay, can we add those to the motion?
Sure. I apologize. I'm trying to look up the language here.
Where do they go though? Are they is it its own separate section in this, or is it a different thing altogether?
It's its own separate section. Jeff and I don't think it really fits in values, and this is more just kind of to have in the back of our mind whenever we're doing these other things. So I would call them guiding principles. Okay, Jeff, did you find that?
I did. I think Megan pulled it. Oh, yeah. I think Megan pulled it up. Can you all see the last motion?
Yep.
Yes, I got it. Mm-hmm. So I would amend the motion to say motion to adopt the mission, vision, and values for TIDC, mission, vision, values, and guiding principles for TIDC, as I have worded them.
And Judge, I apologize. Would you mind reading just those 2 principles again? I just want to we get them the way that you have them.
Principle number 1 is that we defer to local counties when possible. Principle number 2 is that we be aware of and try to reduce the burdens we place on counties when we can.
So moved for that one.
Is there a second?
Second.
Any further discussion? All in favor?
Aye.
Aye.
Any opposed? Okay, thank you very much. That's our last motion. Jeff, what else do we have?
Judge, I think that's it. Unless there's any, I don't know if we have any public comment, but I think those are all the business items we have.
I think you're right. Anybody have a comment? I guess maybe we can't get public comment. Is there any comment by the members of the commission? All right. Thank you all very much. I hope you had a great Thanksgiving, and I hope you have wonderful holidays. And we will see you next year.
Same to you.
Thank
Bye.
you. Good seeing you, Judge. Bye.
Merry Christmas.
Merry Christmas,
everyone.
Bye.
Thanks. Bye.